A lot of people think they have no assets, therefore they don't need to make a will. And I would say, in every case, make a will. One, because you don't know whether you're going to win the lottery, you don't know whether you're going to inherit from your own parents, and if you have children, it's a pretty good reason to make a will in terms of appointing guardians. The one thing that usually decides people about making a will, even though they're not sure about how much they have, is the fact that if they don't have a will, then any other member of their family can apply to deal with their estate, and that might just be one person that you don't like very much. So it's always a good idea to make a will for that alone. A lot of people ask how long it takes to make a will. You can make a will in 2 hours if necessary, but on average it takes about 2.5, 3 weeks to make a will from start to finish. A lot of people ask, do I need to tell my executors and beneficiaries that I've made a will? The simple answer is no, but it's always, I think, useful to double check that your executors are willing to act. Otherwise you may end up with a situation where the executors named in the will say, I don't want to act for whatever reason. They might not just be physically able to deal with it. I had a client who said, I can't understand a word of my previous will. We at the Law House adopt the view that we keep everything as simple as possible. One of the things, because wills are being challenged more and more often, what you don't want is a client or a member of the family saying, my mother didn't understand a word of the will, she just signed the will because she needed to get it done. So we like to be sure that when clients leave the office having signed their wills, they know exactly what's in it. And equally, we are very happy then to defend our position that the client did understand it, should any family member query it. What's wrong with a W.H. Smith will pack? Many people who do their own wills will go to one of the high street stores and buy a will pack. This varies from £9.99 to about £15. At the Law House, we adopt the view that if your estate is worth more than the paper it's written on, you should take legal advice about making a will and the administration of your estate. Full stop. Many people, when they get married, don't realise that the marriage itself may revoke their existing will. In the UK, marriage revokes a will. So a lot of people, when they're maybe getting married, will often make a will in contemplation of marriage. This means that you insert a clause that says, this will is made in contemplation of my marriage to my future husband, and it's not dependent on the marriage taking place, and if we get married, I don't want the will revoked. People think that's quite a funny thing to do, but it's a good idea. A good question is, how much does it cost to make a will? This can vary. This depends on what you have in your estate, what you might be likely to have in your estate through inheritance, and what sort of provisions you want to make for children, or if you want to put in a trust. And we would look at each case individually, and we would vary that depending on whether you are making a will with your partner or your spouse. An increasing issue that comes to the fore when people ask about making wills is the fact that they have members of the family who they really don't want to inherit, and they want to know what they can do in their wills to stop them from inheriting. Sadly, we get more and more queries like this, and families argue. It could be a simple issue that has just festered for 20 years, or it could be an argument they had last week. So we really do probe as to whether this is a long-standing issue and whether there are any real grounds for it. Even though you leave somebody out of your will, this doesn't mean that they can't challenge your will. So if there are very good grounds, we often ask the person making the will to draw up a letter specifying the reasons why that person should not inherit under their will. And this can be they have enough money themselves, they're not financially dependent, you've never got on, it was never your intention for them to benefit. And the real beauty of this letter is it only comes to light if there is any challenge to the will itself.